All right. And good afternoon again to both counsel. We are here this afternoon on the matter of Christopher Brett Kelly, case 17 CF 279. It is a Washington County Division case in the 14th Circuit. Here on a motion for post-conviction relief. Mr. Quintana, do we have the prison online? I'm asking.
I don't know.
Okay. Let's see if they've logged in. I don't know how this was supposed to be done. And Mr. Griffith, thank you for the courtesy of being here. I hope it's not in vain. Typically, we have counsel set up the Zoom call with DOC, but I understand that the jail was doing something in conjunction with DOC to make sure this hearing went off. Is that right?
I believe that they gave them the order, letting them know this is where they're supposed to appear. I don't see anything.
Your Honor, I only learned of the potential Zoom hearing on the 21st when I went to visit Mr. Kelly at the Washington County Jail. I had
At the Washington County Jail or at the prison?
The jail. That's where I thought he would be. But the email, I finally talked with Amanda, and she sent me a copy of an email that she sent me in August saying that the jail was working with the prison for this hearing to be done by Zoom. And
For him, yes.
right. And that had gone to my spam. And I could never find it. My spam only keeps like 2 months evidently, and I never could find, but she sent me a copy of it. And I know it was sent to me, but it was in my spam, I guess. Because that's where all hers have been going. And I tried to fix that, and I'm not IT.
Well, let me do this. Shane, is he at the jail?
No.
Okay, I think we've got the Department of Corrections accommodating us. All right, and thank you, Department of Corrections, for your assistance. Mr. Kelly, can you hear me, sir? Mr. Kelly, can you hear me? Well, I can't hear you. You're muted somehow. There you go. Mr. Kelly, can you hear me now, sir?
Yes, sir.
Okay, all right. And I'm going to ask you to speak up during your time to testify, if you would please, sir, as well. Your attorney, Mr. Quintana, is here in open court along with the state of Florida as represented by Assistant State Attorney Megan Ford. We are here this afternoon to begin your hearing, your evidentiary hearing on your motion for post-conviction relief. I believe you had phrased it initially as a motion to vacate. Well, that was the initial motion to vacate the plea, but now it's the motion for post-conviction relief. We're here on 5 grounds. We're here on grounds of ineffective assistance of counsel. Number 1, challenging competency issues. Ground number 2, failing to investigate or to present a self-defense, affirmative defense. Claim 3, failing to investigate or present a defense of insanity. Ground 4, again, ineffective assistance in failing to properly advise the defendant as to the consequences of entering a plea versus proceeding to trial and maximum possible sentences that he could receive. And then ground 5 is a cumulative error. This court will not proceed on any motion challenging the voluntariness of the plea. That is barred pursuant to the case law that the court has previously cited in the order setting today's evidentiary hearing. So with that backdrop and the burden then being on the defendant, Mr. Quintana, are you prepared to call witnesses?
Yes, Your Honor.
Okay, who would you like to call first?
I would call Reverend Larry Brown.
Okay, and Reverend Brown, if you'll come take your stand, or take the witness stand, if you would, please, sir.
Your Honor, I have never done, I've never.
Just right over there where the bailiff is.
Hearing, but, yeah,
I'll permit it if you move your microphone a little closer to you.
thank you.
At least that way we can capture what you're saying. Sir, if you'll raise your right hand, do you solemnly swear or affirm the testimony you present will be the truth and the whole truth, so help you God? Thank you, sir. You can lower your hand. Mr. Quintana.
Thank you, Your Honor. If you would, sir, tell us your name.
Pastor Brown, Larry Brown.
And where are you employed?
Say again.
Where are you employed?
Self-employed. I have a assistant living and also pastor at Polk Chapel AME Church.
Okay, and what's the name of your assisted living facility?
Tropical Paradise Villa ALF.
Okay. Now, you were there on the day of the incident giving rise to this hearing. Is that correct?
That's correct.
All right, let's talk about the setup of the facility itself where Mr. Kelly and Mr. Holmes were, where they had their rooms. Your facility has a wing going to the east. Is that the east?
That's correct.
Okay. And that wing has 2 rooms on it. Is that right?
That's correct.
Okay. And they're side by side. In one room is a single room for one person, and the second room is a 2-person room. Is that right?
That's correct.
And they have doors opening to a hallway. Is that correct?
That's correct.
If you were going out the east door, the room would be to your left. Is that right?
Right.
Both of them, is number 7 and number 8. Is that correct?
Correct.
And
Reverend Brown, if you'll speak up a little bit, you can move the microphone and straighten it out. That way we can hear you a little bit better. Thank you, sir.
Mm-hmm.
Now, on the afternoon this occurred, you were present there.
Yes.
Is that right?
Yes, I was.
At some point in time, you walked through that corridor where, at least we know, Mr. Kelly was, and you saw him in there. So tell the court what you saw as you walked through that corridor.
Chris' room is the single room that he used, as he always stayed there. The next room was where the 2 came together, where they lived at, where they actually roomed together. And in Mitch, that was somewhere around, I don't know, probably, we have a lady that works for the state. She works for us as well by the name of Renee Perry. She was just getting off.
Okay, let's back up now. When you walked by there, you saw Mr. Kelly.
Yes.
What was he doing?
Ooh.
Was he sitting on his bed watching TV?
I really can't say. I don't know. But as I can recollect, he was in his room. That's what it seemed like. He was in his room.
Okay, and you could see him.
Yes. Mm-hmm.
Okay. Now, was the door open in the next room?
No, I won't say that. As I can look back, just trying to remember, because that's normally the time everybody start going to their rooms, kind of relaxing, whatever they want to do.
Right.
So I say he was in his room. The door was, I don't know if it was open or closed, but I remember, I know they was all there.
Okay. But you don't recall seeing Mr. Holmes at all. So the door could have been closed.
Could have been.
Okay.
It could have been.
So you walked out
the east door, and where did that take you?
Take it to the outside.
Okay, and what did you do out there?
They normally they walk to the east side. That's where they smoke. We have a designated area.
Right.
And that's the smoking area.
Okay.
That is the east side. The front entry is not for smoking. We also have a south side, which directly goes to the backyard. You can smoke out there, but they always sit there because it's a sitting area.
Okay.
You can just sit under, kind of relax, smoke, and you can go into the yard. But that's normal. That's where it goes.
Do you recall what you were doing outside?
Yes, I had just left. Renee had just clocked out. I walked out as I was going to the backyard. I was going out because I was servicing the mower. I had been mowing previously, so I'm going to go back out. It was right there at the end of the concrete, probably 25, 30 feet from the door. And there's a fence that actually go around, and I was there.
What time approximately did you go through that door?
I don't know. Probably had to be somewhere 5-something, 5:30, probably 5:15. Just guessing.
Okay, according to the incident report, you called the police at 6:40, around 6:50, 6:48, I think it was.
Okay.
All right. And now you had an employee that you told me you called back. What time does she get off?
I believe she gets off around 5 or 5:30, somewhere in that neighborhood.
Okay, so somewhere between 5:30 and 6?
Yes.
Okay. All right, so you're outside, and at some point you see Mr. Kelly, is that right?
He kind of rushes out to me.
And he tells you that he had stabbed the guy.
Yes, he's out stabbed. What's his name? I can't think of his name. Holmes, right. And I didn't believe it until I saw blood on him. And when I saw blood on him, I said, well, it's got to be something wrong. So I went in. That's what happened.
And so you called the police?
Yes.
All right. Now, at the time you called the police,
first I didn't call the police. I called 911 for help.
Okay.
Because that is our first response. I was with Enron, so I was in safety. I used to be in safety. So my first response is for help.
Right. Get a name in, sir.
Yes.
Okay.
And I went in and tried to hold pressure, try to help him. That was all.
Okay. So at the time that you spoke to the police, well, first off, you didn't see what happened at all.
I don't know.
So you didn't know what happened.
Didn't know what happened.
You just knew he was there and he was bleeding.
That's it.
Now, did that strike you as odd that something had happened where Mr. Kelly was involved like that?
Not unusual. Well, it struck me because they never had any arguments.
There'd never been any problem.
They never had no problem.
Okay.
No.
Now, Mr. Kelly was there at your facility because he was court ordered to be there. Is that right?
Not really. His father and I agreed. His father, Tom Kelly, called me and asked me, could we take him? Because, I know parents, as parents, people have kids, we've had problems with the kids, and sometimes other people can help a little more than the parents. So I agreed. I asked.
Okay, you may not have known about the court order.
Well, I didn't know nothing about the court order.
Okay, all right, that's fair enough. Now, Mr. Kelly was there because of mental health issues, is that correct?
I say that now. Well, I'm sure it was because kind of behavior too. Behavior.
Right.
Behavior. Yeah.
Now, what was Mr. Holmes there for?
He was. My wife said it was schizophrenic and bipolar.
Okay, so he had mental health issues also?
Yes.
Okay. Now, have you ever known Mr. Kelly to be dishonest with you?
No.
Is he could you imagine what had caused, well, that's asking for speculation, so I'm not going to ask you to speculate. That's all I have.
Ms. Ford, any questions for the witness?
When you went to the victim who was stabbed, did you see any other weapons on that victim?
No, there was no one is allowed to have weapons unless when I say that anytime they come and we have people to come in, they have to tell us they can't bring anything in. It's like their search. So it was like, where did this come from? I don't know.
Did Mr. Kelly have the weapon on him when he told you?
No.
Did Mr. Kelly tell you what happened or what led up to this?
No.
When the police arrived, did you see them talk to Mr. Kelly?
I think they took him off, but I don't know. They took him off to the car, but other than that, I don't know what they talked about.
Did Mr. Kelly ever tell you that he was acting in self-defense?
No.
Did Mr. Kelly ever bring up issues with this individual that he felt like he needed self-defense against?
Mm-mm.
No further questions.
Is there redirect, Mr. Quintana?
Yes, Your Honor. I think we need to quiet that, Your Honor. It's distracting me terribly.
Can the DOC officials perhaps close that door a little bit more so we can hear a little bit better during the hearing? We would very much appreciate that. Thank you. Go ahead, Mr. Quintana.
I forgot my question. Mr. Kelly gave you knives on several occasions, didn't he?
Yes, when his father would come up and he would go off and they would buy. Actually, he went to his dad would take him like to eat out, and even Tom would even take. He even asked me to go with him. I would go to Chinese. We'd go out on every other Fridays and go and eat. And sometimes I wouldn't go. So when I didn't go, Chris would always. I guess his father would take him somewhere, and they would shop. And he would buy knives, and Chris would come back, and he'd come back, hey, Reb, I bought you a knife, because I'm a hunting person.
Right.
I hunt. So because of that, and Chris knew that. He knew that. I'm an outside person.
Did Chris ever give anyone any problem at your facility?
No. Mm-mm.
Okay, now, how was his meds administered?
They are actually administered through life management. He has a mental and he has a medical. He's taking once a month to his medical, also to his mental. And his meds is actually called in so that he makes sure that his meds, we don't never went out of meds because they always call them in and they package them in packs. So it's like bubble packs.
Who was responsible for him taking his meds?
We have trained persons to do medication, and we always, we write down when we give them, and he takes them.
So y'all actually administer the medication?
Yes. Well, we administer to make sure he did take it. He takes it. We didn't have anything to do with what kind of meds he takes.
Do you remember how many meds he was on when he was there at the facility?
I couldn't say. I couldn't say because I don't really. I don't know. I really don't. I do know at a time that he he went to life management one time, and I could always tell him this: if something is not right, talk to me. Be straight with me. And he didn't want to get on one meds, but he came back that week and he came back to me, he said, Rev, he said, I got to get back on my meds. So I would call the nurse and we put it right back on. Because sometimes, he would hear voices.
He'd hear voices.
I'm sure he did. I'm sure he did,
Yeah.
because I'm sure he did.
What did he call you? How did he address you?
Ooh, he got the way he loved me. He really loved me. Because I was straightforward. I'm just straightforward. If you love me, fine. If you don't, I'm gonna love you anyhow. That's who I am. You can accept it, but I'm always gonna be the same person. And he found that out when he first came. He asked me to do something one time for some kind of a way of being manipulative to his mother and dad when he first came, and he was in his room. He was in a private room, and more in the front. As you go in to the front to the right, he was there, and he asked me to do that, and I got on him. I said, son, let me tell you something. I said, Rev, don't manipulate people. I don't do this here. I will not. Don't you ever ask me of that again. And I said, that's very disrespectful. And
let me ask you this. Did he have a lot of money?
now now I can't say he had a lot of money, but I'm sure his father gave him money. He didn't give a lot of money because he didn't really need it. He had his meals there. They bought him his cigarettes, but at the same time, he didn't need anything other than, and we didn't go out all the time. We didn't do that. We just don't,
Did you ever lend him money?
I don't know. I didn't never lend him money. And the reason why, if I do it for him, I got to do it for others.
Right.
So I don't start something. I got to start to everybody else. That's mistreating one person different from another. I don't do that. No.
So if the police had reported that you would give him money and his father would pay you back, that would not be correct. Is that correct?
No.
That would not be true.
That is correct. That's
Okay,
not
so-
correct.
Okay, if the police reported that, that'd be incorrect.
That's incorrect.
That's all I have.
Open the door. So Ms. Ford?
Yeah, I need to cycle back to that knives comment.
Mhm.
You were telling us that Christopher would bring knives to the facility on occasion.
Like Dutches, like a Dutch.
Are those allowed in the facility?
Oh, it's not in the facility.
Okay.
I have him personal
Uh-huh.
in a case myself.
Okay.
Okay. He would bring them to me when he walked in. They're not in the facility. No.
Okay. So he was not allowed to have them
No.
in his room or anywhere.
No.
Okay. Were you able to look at the knife that was used in this?
No.
Are you aware where the knife came from that was used in this?
No, I'm not.
And why are you not?
I believe I don't. Chris and his father came up to the Watermelon Festival.
I'm going to object to any speculation.
He says he doesn't know, so he's speculating. I'll sustain that.
I don't know.
You don't have to answer that,
So
sir.
you didn't do any investigation to determine where that knife may have come from on your facility that caused a murder?
I didn't even know where it was at until that happened.
Okay. And to this day, you don't know where that knife came
Don't
from?
know where it came from.
Okay. As to the money issue, it was your understanding that Chris would get money, but it would come from his father? Does that explain your testimony?
That's correct.
And that you personally never gave him money?
No.
Nothing further.
Mr. Quintana, anything else?
No, Your Honor. Thank you, Reverend Brown.
Thank you, Reverend Brown. You're free
You're
to go. Thank you for coming and being with us today.
welcome.
Thank you, sir.
Okay.
All right, and Mr. Quintana, your next witness?
Floyd Griffith.
All right, we'll get Mr. Griffith out from the hallway then as well. And Mr. Griffith, if you'll take your station in the witness box, please, sir. Certainly, the court recognizes Mr. Griffith as a member of the Florida Bar and practicing attorney here in the 14th Circuit. So if you'll raise your right hand for purposes of this evidentiary hearing, do you solemnly swear or affirm the testimony you present will be the truth and the whole truth, so help you God?
I do.
Thank you, sir.
If you would, sir, tell us your name.
Floyd Griffith.
And Mr. Griffith, at the time this case was pending trial, what was your position with the state?
I was a full-time assistant public defender working here in Chipley, Florida, handling felony cases.
Okay, and did you have an occasion to represent Christopher Kelly in this case?
I did.
If you would, sir, tell us when you first met with him.
I probably met with him in the courtroom when I was appointed to represent him, but I went out to the jail on September 15th of 2017, I believe it would have been. And we must have started discussing the case, and Mr. Kelly got up and just left the interview room.
I beg your pardon?
Mr. Kelly just got up and left the interview room.
Okay,
He walked out. I thought that was rather strange.
okay.
I'd already spoken, or maybe it was after that I spoke with his father. He asked me to talk to his father about his history. He'd been in some trouble before, been Baker acted. He was charged with some offense down in Bay County, I think, and wound up being found incompetent to proceed in that case and was sent to Florida State Hospital where his competency was restored, I guess, with the proper medication. So he told me about some of Mr. Kelly's background. And so I realized there could be a problem here.
Okay, did you ever have a conversation with him where he told you what happened?
Where he told me what happened?
Yes, sir.
Partial conversations, yes.
Okay, and what did he tell you happened?
Oh, I don't remember. That's been 5 years ago exactly. We did discuss the possibility of self-defense later in my representation.
Right, and what did you tell him about that?
About the self-defense?
Yes.
That would have been, I went to see him and we discussed some plea negotiations in January and February, and I went back on February 27th to see him at the jail. To start that visit, he told me he did not want 40 years, and then he told me that he wanted self-defense. And my note indicates that I must have mentioned multiple stab wounds, which was probably a mistake at that time if I'd read Dr. Schuler's report carefully, because she said that if he's confronted in any way, that he doesn't react well. And so pointing out to him that there were multiple stab wounds, he made a statement, "I don't grow old," and I put that in quotation marks because I thought it was rather unusual.
What did you think was unusual about that?
Well, people do grow old.
Yeah, but what particularly struck you about that, other than the fact that people grow old?
It was a strange thing to be saying in the context of our visit.
Okay.
I don't grow old. It didn't add anything to the conversation. He said, "I stabbed him a couple of times. I did not do that." He wanted me to help him in prison. I'm not sure why I even wrote that down or what that meant. Tried to give him the medical examiner's report. I did. And he refused it and said, "I don't want anything from you. Just give me the 40 years.
Okay, at some point in time, you were concerned about his mental health. Is that correct?
Yes.
When did that occur and why did that occur?
Well, I mentioned earlier that I had a conversation with his father. I think I talked to Mark Graham, who represented him in Bay County, about the time that he was determined incompetent to proceed and was sent to Florida State Hospital and had his competency restored. So all those things were adding up. So I filed a motion to have a competency evaluation. I think I talked to Doug White about it. Doug used to work down in the Bay County office, you know, Doug. And Doug suggested that I get a confidential evaluation done. So we employed Dr. Schuler, Celeste Schuler, and she evaluated him, and she told us it would be sometime in January before she got around to seeing him. So she did an evaluation and furnished the report to me.
And what she did was a competency evaluation.
Yes.
Okay. To proceed. To proceed?
Yes.
Okay. So he was not at any point declared incompetent to proceed. Was he able to, it sounds to me like he was having a hard time communicating with you. Is that fair?
There was some difficulty in that. I'm sure we talked about more than I made notes about because I don't write everything down when I visit with a client. But during that first jail visit, I like to go over the discovery with them, explain what's in the discovery and that sort of stuff. And I may have been in the process of doing that when he got up and left the room.
Do you recall him ever telling you what happened?
He could have. I won't say he didn't.
Okay, let me see if something might refresh your recollection. Did he ever tell you that the person took money from him?
I read that in the investigative report. He may have told me that.
Okay. Did that not strike you as potential good evidence for him?
There was one thing in the discovery that gave me some concern about that, and that was the fellow, I don't remember his name, that ran the group home he was staying in. When he was talking to one of the officers that was investigating the case, he said that Chris, Mr. Kelly, never had any money. So there would be a witness that would contradict Chris saying that he tried to take his money by saying Chris didn't have any money to take.
Okay.
So that would have been a problem with that.
All right. So did you ever discuss any kind of insanity defense, whether it be temporary or whatever, with Chris?
Probably briefly. Mostly I relied on the report that I got, and I offered him the report.
Let me ask you this. What evidence did the state have to prove their case?
What evidence did they have to prove their case? I'm getting old, but let me do the best I can. They came out there to investigate a problem at the group home. And when they got there, they found that there was Chris was standing outside with blood on his hands and held his hands out and said, "I killed him." Where is he? In the room. What'd you kill him with? A knife. And at some point he said, he tried to take my money or he took my money, something like that. So that was what they found when they got there.
Did you ever learn, okay, other than the fact that Holmes took his money or whatever, did you learn anything else from Mr. Kelly about how the stabbing ended up happening?
No. Mr. Kelly never told me that he tried to attack me. He never went into any details about how he tried to take the money or what caused him to stab him a number of times.
But you obviously had a communication problem with him. Would you agree?
I'll agree with that.
Yeah. Because I've had similar.
Objection.
Sustain me.
I'm sorry.
Counsel is testifying.
Right. Did you ever talk about a potential, well, obviously you wouldn't have talked about a potential stand your ground because you never knew about how the stabbing ended up occurring. Is that right?
When I was reviewing this, I think he did make mention of stand your ground at some point.
Okay, and what did he say about that?
What about stand your ground? And I may have written him a letter about that. I think I saw something in the file relating to that, or, stand your ground is you have the right to use reasonable force to avoid the use of deadly force to avoid deadly force against you, or reasonable force if it's non-deadly force. It's basically self-defense.
Do you have that that letter?
Do I have it?
Yes.
Have you got time? I'll look for it.
I think that at least I have proposed exhibits from the state, and it would be number 4 that I have as far as the letter.
Oh, this may be that letter dated March 18th you're referring to,
Yes, sir.
Judge?
I haven't seen that.
You mentioned
Oh, I
self-defense.
see her.
You have not seen that, Mr. Quintana?
I beg your pardon?
You have not seen that?
I have not until just now.
Part of,
The state provided it to me. I'm sitting here looking at it.
I think it was in the state's response too that we filed in 2019.
Okay, this is the self-defense letter.
Yes, sir, in part.
Okay. All right. Was there a different one that talked about stand your ground?
I don't know.
Okay. And I have seen this, Your Honor, when I looked at their response.
Just
And I
so the
just-
record is clear, does the state wish to offer this out of order at this point?
Yes, at the
So
time.
it's consistent?
Yeah, this would be state's number 4.
And any objection to
No.
that? I'll admit states 4 then. The March 18th, 2018 letter authored by Mr. Griffith to Mr. Kelly.
Okay. So other than explaining what stand your ground is legally, did you have any further discussions with Mr. Kelly about it?
I don't know that I explained stand your ground legally in this letter. Stand your ground means if you're in a place where you have a right to be, you can, avoid certain situations. I think he was in the other guy's room.
Or you think, so you're speculating?
That's what the report says. I wasn't there.
Okay.
I don't know if there's any indication that the other man came into Chris's room. I mean, anything's possible, but
Do you feel like you ever had a good conversation with Mr. Kelly where he told you what happened?
well, good meaning. Not
Productive.
the best.
Productive. In other words, was he and you able to communicate was he able to communicate to you how this happened?
Not in any great detail.
Okay. Now, at some point in time, after you walked out of the room the first time you tried to talk to him, did you think that was strange?
That he never,
That he walked out of the room?
I thought it was strange. I mean, I'd seen other clients do it before.
Okay. Yeah. Okay, and then you talked to his dad, and his dad gave you some history, the mental health history.
Right.
And at that point, you hired Dr. Schuler to evaluate him.
That's correct.
This was a private report that the state would not have been privy to at the time. Is that correct?
That is correct.
Okay, was there anything in that report that bothered you?
Well, from one point of view, it bothered me that Chris had told the lady that examined him that he'd taken 5 painkillers that day. And I'm not sure what painkillers he had available to him, but it bothered me so far as the insanity defense would go, or it apparently affected Dr. Pritchard's ability to determine, what caused him to do what he did. Was it the drugs? Was it mental illness?
Well, but she was doing a competency evaluation.
Yes.
And she only had, she was only able to review. Where did she get the information that she reviewed to do this assessment?
From our office.
Okay, and she was only able to review, well, this is what she says she did: interview and mental status of examination of Mr. Kelly, interview with Mr. Kelly's father, Tom Kelly, review available records. What available records did she get to review?
The ones that we sent her.
What would those have been?
Essentially the discovery that I had been furnished at that time,
Okay.
the information, probable cause statement,
Anything else?
a long call history record
Okay.
that really didn't shed much light on anything. And then there's a much longer report. Let's see if it has a label. Well, Scott Marshall's report, and I think there was Kenny Brock, Justin Taylor, Charlie Williams, I think, was the officer that did a lot of the work down there.
Right.
Yeah, he did about 2 pages worth. That's where most of the information was. So I think she had these, this is attached to the letter we sent to her.
Okay, and that is the police report.
The discovery that we had at that
Right,
time.
okay.
That was in December of 2017.
Okay. When you talk to Mr. Kelly, his dad, Tom Kelly, he advised you that his son had been arrested in Bay County, had been found incompetent, and in fact ended up being required to live in the assisted living facility by the Bay County Court, right?
Well, yeah, he went to Florida State Hospital where his competency was restored, where he could enter a plea. And I think as a part of that plea, he had to live in a assisted living facility.
Do you have any idea the circumstances of his arrest down there?
Not in Bay County, no.
Do you have any?
Well, there might have been something about he hit some police officers or something. But I didn't do a thorough in-depth investigation of what happened in Bay County.
Did you ever seek a copy of the report that found Mr. Kelly incompetent to stand trial?
I don't remember.
Well, go ahead.
I got a petition for involuntary placement. That was one of the Baker Act cases in Bay County.
Which one of those did you get?
Looking for a date on it. 2/11/11, 2/10/11. Not real good writing. Yeah, I think it's probably February 11th of 2011. It's just a Baker Act petition.
Did you have more than one?
Well, let me keep looking. Maybe I'm gotten to a better place in the file to find things like that.
While the witness is looking, do both counsel want me to admit State's Exhibit 2, which was
Yes.
Dr. Schuler's evaluation?
Yes.
Okay, let me admit that as State's 2. Again, out of order, but just for expediency's sake, we've been talking about it. Makes more sense with the record.
This looks like a transfer evaluation that must have been related to the other one. It's dated February 24th, February 14th, February 24th of 2011. So that was one of the Baker Act ones. This is, this may be the Bay County records. It's an order adjudicating the defendant competent to proceed in case number, looks like 2014-1749A down in Bay County.
And what was the conclusion of the judge in that report?
Well, I've got the order adjudging him to be competent, but I don't know that I have the report. The findings were that he was restored to competency and was competent to proceed to trial.
First witness, Your Honor.
Yes, sir.
May I see that, please, sir? If you would, read the conclusion of law, Judge, as conclusion of law 8.
It's either a typo or the judge ignored his own findings of fact,
What does it say?
but I think it resulted in a plea.
Tell us what it says, please.
The judge says, in the findings of fact, he said he was competent to proceed, and then in the conclusions of law, he says the defendant is, or she says, the defendant is incompetent to proceed due to the defendant's mental illness. Maybe this was the preliminary one
Yeah.
that got him sent to Florida State Hospital. He was never found competent to proceed in that case.
That's the order. That's all I can say.
Well, let me see what the order. The order is titled Order Adjudging Defendant Competent to Proceed.
I understand. But you accurately read it. Your Honor, I'm going to ask the court to take judicial notice of some records from Bay County. You require me to get a certified copy?
No.
Does anyone else have this order?
I see it. I have it in my computer file.
Okay, well, it's an order adjudging him competent to proceed, and it goes through all the steps they went through, and I misread one typo in this order, I think.
Your Honor, I ask you to take judicial notice of that order.
And can we put on the record what case that would be?
It is case 14 CF 1749, a Bay County division case in the 14th Judicial Circuit. And 2 orders were entered on March 26th of 2015. Number 1, an order adjudging defendant competent to proceed. Mr. Quintana has discussed that. And then the second order, docket number 82, a community treatment plan.
Okay, let's back up now. Let's go back to where we were. Did you ever see the order finding him incompetent? Not the order, the evaluation finding him incompetent in that case?
I don't think so.
Would you be surprised if he was found incompetent because of severe schizophrenic how does it term to use this? Symptoms of schizoaffective disorder?
I've seen that language.
And you said you thought that he may have hit a couple of police officers. Were you aware that in 2014, he was found by the police officers beating up stop signs and pulling them out of the ground?
Whatever happened, I'm not aware of it.
And were you aware that when they went to try to arrest him, that he resisted.
I was aware of that. I don't know.
Had you known that, would you have maybe looked in further into a possible insanity issue?
Well, I'm not an expert in that field. Well, I hired an expert to take a look at it. And when she indicated that he had taken 5 painkillers that day, that whatever fire I had lit under me about insanity sort of dwindled.
Okay, but you weren't even aware of this order, and
I think she makes mention of it in her report. Or maybe I'm wrong.
the judge has a report. Your Honor, you have the report and you can read it. I don't know whether she mentioned, I don't think she did, but
And you may be right, Mr. Quintana.
you had only one Baker Act petition. Are you aware there were at least 2 others?
I think his father mentioned that, and that may be mentioned in the report too.
Okay. How many times are you aware that Mr. Kelly had been hospitalized for mental health issues?
Off the top of my head, I know he was hospitalized in Florida State Hospital as a result of that 2014 case. I think.
Right.
I found the report now. Other than that, hospitalized, he may have been Baker acted, which may be what you mean by hospitalized a couple of times, but I'm not aware of any other.
Would it surprise you that during his adolescence and young adulthood, he was hospitalized approximately 10 times?
How many?
10.
No, I don't know about his youthful history.
Would that have caused you to look further into a potential insanity issue, whether it be temporary or generally?
Not me, probably. I mean, that's why I get someone that knows more about it than I do to
You
look at
said
it.
you have a report. Did you find what report are you referring to?
The one from Dr. Schuler.
Okay, not the one from Dr. David Smith.
No, I don't think I got his report.
Okay.
I got the order from down there that you pointed out to me has a typo in it.
Your Honor, we would offer this and 3 petitions. I think there's 3 here. I guess we would like to mark. Plaintiff Exhibit 1, the forensic report of Dr. Smith.
There's two reports in that case, Ms. Quintana.
Yes.
In case 14 CF 179,
Right.
but you're only offering one.
Right now, yes. But
Okay.
that's not to say I'm not going to offer the other.
Okay, I just want to make sure
Oh, okay, well.
out of
I'll do that.
completeness, we have everything in there.
What you're talking about, Your Honor, is the state hospitals report.
Yes, sir. So we can do that as a composite one. Any objection by the state?
No objection.
So defendant one will be the report judging, or rather the forensic evaluation that led to the defendant being adjudged incompetent to proceed, that being 7/17/2014. And then the second evaluation would have been on or about January 13th of 2015. Is that right, Mr.?
January 7th, Your Honor. 15.
Okay, it must have been filed with the clerk on the 13th, but January 13th of 2015. And that led to the adjudication of competency to proceed, or at least the order entitled that.
And
Do one and two. We'll just do it just for record's sake.
so one would be Dr. Smith, two would be the state hospitals, and three will be the three Baker Act petitions.
Let me look at the Baker Act. Do we know if those were ruled upon, Mr. Quintana, the Baker Act petitions?
No, Your Honor, they were all because he was being filed, I believe, because he was being uncooperative. They were filed and then he became cooperative, I guess.
Okay, and the state has seen these as
I have
well?
not seen the Baker Act. petition.
Okay, if you'll hand those down, I'll provisionally admit it as defense 3 composite.
And we'll pass it.
All right, then, so admitted.
Hey, let's go back to Dr. Schuler's evaluation. Yes, I had asked you if there was anything that you saw that bothered you, and I think you said the fact that he had taken 5 painkillers that day. Anything else?
Well, I'm looking through the report where Dr. Schuler is going through his prior history with the mental health system. Apparently, she looked into that, or maybe she just took Mr. Kelly's word for what had happened about his behavioral commitments, and he estimated he'd been psychologically or psychiatrically hospitalized around 10 times. He said he was placed in Florida State Hospital for about 6 months in 2015. Sometimes he doesn't take his medications and doesn't think straight. And he has delusions when he's not medicated, describes seeing bright, various things. You don't have a copy of this report, Mr. Quintana?
Yes, I'm looking at it.
Oh, okay.
Is there anything?
Well, I'm trying to go through it and see, was there anything else that bothered me about the reports?
Let me help you out.
Thank you.
So look at page 5, paragraph 4.
Okay.
He was borderline on his ability to verbalize his wants and needs, communicate without significant difficulty, Did you talk to Dr. Schuler and tell her about your history with him and y'all's ability to communicate?
I'm not sure if I did.
Well, her report does not indicate that.
Right.
Okay, look at page 6, paragraph 6. He was also borderline.
Hang on, let him read it. Let him read it.
Okay, I'm sorry.
Okay, I've read it.
Okay. She said he was borderline acceptable. He gets irritated, frustrated, and agitated when challenged.
Yes.
Okay.
And I may have experienced some of that.
Okay. Did either of those borderline findings bother you? I mean,
Well, they have to bother you some.
well, did you consider that more in-depth evaluation would be appropriate?
No.
Okay, this competency assessment was done at your request. State wasn't privy to it, but it was done right before he entered his plea. Is that correct?
Shortly before he entered his plea, I think would be an accurate statement. February 15th is the date of the report of 2018.
Did she, there, I want you to look at one other place. Page 2, bottom line. Read the last line.
You said he feels over-medicated?
Yes.
I'm not sure when he feels over-medicated from reading that last line in isolation. He's talking about various things in his history, so I don't know if he meant that he felt over-medicated at that point in time when she was interviewing him. He stated he does not feel paranoid and is not experiencing hallucinations at this time. He said he feels over-medicated, so maybe he did feel over-medicated.
Well, that would be my reading of it, is that at the time he's talking to her, he feels over-medicated.
Okay. He may have felt that way.
Okay, would that bother you?
His opinion as to whether he was over-medicated, did it bother her, I think would be the more appropriate question.
Well, she was evaluating him for competency to proceed. You were about to have him enter a plea to 40 years in the case. Did that bother you? Did you think you needed to look into that?
He was the one that indicated that he wanted to take the plea. The odds were not favorable, I didn't think, if we went to trial for a number of reasons. And I made him aware of what his offer was, and he said he wanted to take it.
Well, initially, he didn't want to take the offer because the offer was.
Objection, counsel testifying.
Sustained.
What was the original offer?
The original offer that we made was 15 years. I think the state's original offer was 45 years.
Okay, so he didn't want to take the 45. He was trying to see if they'd take 15.
And then 25. When they turned down the 15 years, he came back and said, offer him 25 years, and I did that. And then next, Ms. Jeffcoat said she'd spoken with the victim's family, and they said the least they would accept is 40 years. And at the end of our conversation at the jail, he said he would take the 40 years.
Okay. At this point in time, are y'all having better communication?
Must have been some better communication until the end of that conversation, when he decided he didn't want I think it was the medical examiner's report I tried to give him. Said he didn't want anything from me.
Well, the reason, did you tell him you don't have a case as far as self-defense?
I would have told him what problems there were with his self-defense.
And the problems you saw were the extraordinary number of stab wounds, correct?
That's one problem. The other is if I was to use self-defense on his behalf, it'd be best if he could get on the stand and effectively testify, which I wasn't sure if he would be able to do that, especially given cross-examination and how he handles confrontation. That would have been a problem with
Do you
self-defense.
think the confrontation would have triggered him? Perhaps.
I'm sorry?
Do you believe the confrontation of cross-examination might trigger him?
He may have difficulty in that situation, yes.
Well, in the conversations you say you experienced where he didn't handle the communication very well, you were expecting something similar to happen in the courtroom, right?
I saw a realistic possibility of that. I mean, and it doesn't have to be a confrontation. If you disagree with him, he would get upset.
Okay. So you would agree that he was easily upset in communication?
I think that's a fair statement.
Now, one of the questions the judge asked him during the plea colloquy was, are you under any medications, yada, yada, yada. Did it concern you how he might answer that?
Probably not at the time. I don't recall what his answer was.
Do you think if you had told Dr. Schuler about the communication problems you had with Mr. Kelly and about your concern about his ability to testify, that she may have had a different opinion?
I don't know. From my way of looking at the case, you've got the multiple stab wounds. You've got a witness saying that he didn't have any money to be taken from him anyway. And his probable difficulty with testifying, I just didn't see self-defense working that well in this case. I mean, it was a defense that's there, but the odds of winning on that would be pretty slim.
You said that you've got somewhere in your file the police saying that someone saying he never had any money?
Yes.
Can you show me that?
If you've got time. I don't think it'll take that long to find this.
That one, I'm going to have time.
Well, I think it's
Would it be in the investigative report?
in the investigative report.
Do you have a copy of that?
Made contact with Larry Brown. Oh, I should say where I'm reading from and what I'm reading. This is the it says IBL report header at the top of the page, supplement number 2, Washington County Sheriff's Office, and I'm looking at page 5 of 5, the first full paragraph. Upon arrival back at the crime scene, I made contact with Lieutenant Brock, who was typing a search warrant, and advised him the information for the search warrant. I then made contact with Larry Brown and collected a sworn statement of this incident. I hope this is where that statement is. During the statement, he said he was about 150 feet from the door to the home working with a lawnmower. He said Kelly walked up to him with his hands bloody and stated he killed him. He asked him who. He said the guy in there. Brown stated he was confused but saw the blood and called 911. He said then he went inside and found Holmes sitting on the floor next to the bed.
Excuse me, if you find what I've asked for, that's what I'm looking for.
Okay, well, let me see if I can do that. Okay, I'm looking, well, I'll read it, but it's near the bottom of that paragraph. I also asked Mr. Brown if Kelly had a large amount of money, and he stated Kelly never had any money and would always borrow $5 from him when his dad would come see him, that he would give it back to me. So this is where the guy that was running the place said that Mr. Kelly never had money.
Well, he didn't have large amounts of money. We know that, right?
Well, Mr. Kelly asked him if he had a large amount of money, and he said that was the question that he was asked, and his answer was Kelly never had any money and would borrow money.
So you never asked Mr. Kelly about the money that was supposedly taken from him, right?
I may have during the first interview, but I didn't make any notes of it. I can't tell you one way or the other for certain.
Okay.
I would have gone over the discovery with him.
All right. Do you know how much money Mr. Kelly had when he was arrested?
Not off the top of my head.
You know how much money they put in his bank account?
No, I don't.
Did you ever have a good understanding of what happened?
For someone who was not there, I have some idea what happened.
What do you think happened?
I think a man was stabbed. I think another man had blood all over him, said I killed him, was holding his hands out. What led up to the stabbing, I don't know. I don't know if it was a result of an attempted robbery or taking too many pain pills or mental illness for that matter.
So I'll have it this time.
Ms. Ford? And I'll allow you an expanded cross for entry of exhibits just for time's sake.
All right, and so we're going to work down through the order, and the first thing I want to discuss with you is the evaluation. So you told us earlier your first meeting with Mr. Kelly was on September 15th, is that correct?
Yes.
And that was the meeting where Mr. Kelly got out and left. Is that what occurred?
That's the only note I put on there. I'm sure we were talking about the discovery, but the only thing I thought significant enough to make a note about was he just left the interview room.
Has that ever happened to you before as a defense attorney?
Yes.
And why do clients get up and leave?
I don't know. Various reasons.
So as a result of that meeting, did you look into Mr. Kelly's competency?
It wasn't because he left the interview room. I mean, I was tipped off by his father. Mr. Kelly may have told me at the time when I met with him that he'd had some mental health issues. There were numerous sources. I talked to Mark Graham, who represented him down there in Bay County. So I had reason to believe that he'd had some mental health problems in the past.
Okay. So from September to January, and I'm going to show you states number 1, you kind of began to investigate issues with the defendant.
Yes, stage number 1 is a motion for examination to determine competency that I filed on his behalf.
And what date was that filed?
January 9th of 2018.
So between September and January, you gathered some opinions. You talked to a few folks about Mr. Kelly, kind of looked at his prior history and made the determination to do the competency evaluation.
That's when we filed the motion, yes.
Okay. Can you tell me a little bit more about the evaluation and what type of evaluation you requested?
We filed a motion for examination to determine competency originally, and by the time that Dr. Sheila was going to be able to work on it, I had talked to, what's my friend's name down there in Bay County, Doug White, and told him a little bit about the case, and he had recommended, he'd done more murder cases than I had for sure,
Mm-hmm.
and he recommended that I get a confidential competency assessment. And so that's what we asked Dr. Schuler to do, and that's what she did.
And why did you do a confidential instead of a traditional evaluation?
I think this one would have been filed with the court, and the state would have had access to it and found out more information than they knew at the time. It's a good idea to keep it confidential, I thought, if it was going to go to trial.
If it was going to go to trial. If it came back that he was not competent, would you have filed it with the court?
If he was not competent, yes.
Okay. So now let's talk a little bit about states number 2, which is the evaluation. Do you have that in your hand?
Dr. Schuler's evaluation, yes.
Okay, and so we know on June 19th, you filed a motion for it. And what date did she finish up an evaluation of your client?
The date of the report is February 15th of 2018.
And did you review it when you received it?
I'm sure I did.
Okay. Does the evaluation state that Mr. Kelly was incompetent?
Let me check it carefully because there's been some tricky orders today, but I'm pretty sure that the evaluation says he was competent.
Have you reviewed evaluations of competency before?
Yes,
When you evaluated this competency evaluation, did it seem appropriate to you?
yes.
Did you have any reason to disagree with the report?
No,
Did it appear to you that Dr. Schuler adequately looked at the mental health of your client?
I'm really not qualified to give that kind of opinion, but I don't have any training in psychology
Right.
but it looks like competency assessment reports that I've seen before. It looks similar to those.
Did it seem like she had looked at his history?
Yes.
Did it seem like she had interviewed him thoroughly?
That she examined him thoroughly?
Uh-huh.
I guess.
And something we touched on earlier, does the evaluation kind of help you see the needs of your client and how you could better represent him?
In some ways, yes.
Did it give you some ideas about how to handle Mr. Kelly when you spoke with him?
It should have. I don't know that I succeeded in that, but
Did you feel after you received this evaluation, you needed to get another evaluation?
no.
Let's talk about, did the evaluation essentially find that the defendant had the present ability to consult with his counsel?
I think that was one of the marginal findings.
But he could.
He could.
After you received this evaluation, did you ever have a feeling that he didn't understand the proceedings or what was going on?
No.
Was he able to articulate to you plea offers that he was willing to accept?
Yes, I mean, he knew that part of it, and I thought he offered 15 years, fine, let's give it a try. Actually, it was 15 to 25, and I said, well, let's start at 15, maybe they'll take that, and they didn't, then we offered 25.
So he seemed to have an understanding of what the process was at that point, is that correct?
Yes,
Earlier, I think you said February 27th, that was that last meeting. So if the report was done February 15th, on February 27th, you had a meeting with him. Is that correct?
that's correct.
And this is where he told you he did not want the 40 years
That's
at the
where
beginning?
That's where he told me, yes, at the beginning, he said he did not want the 40 years. He wanted to do self-defense. I mentioned multiple stab wounds and anyway, but at the end of that meeting, he said, just give me the 40 years.
So we know on February 15th, 2018, Dr. Schuler said he was competent, and February 27th, you've talked to him. I want to show you states number 3. Do you recognize this?
It looks like a plea form,
And what date is on the plea form?
March 19th of 2018.
Okay, so between February 27th and March 19th, did you see any reason or any issues going on with Mr. Kelly between those dates?
Not that I remember.
Had there been a concern about his mental abilities or his competency, what would you have done?
If it was really significant, I may have asked for another competency evaluation, but I don't remember anything that would have triggered that.
If he was deteriorating in the jail, would they have contacted you to let you know that he was having issues?
They could have. They didn't in this case, but
That was my next question. No one notified you that there was any issues going on with Mr. Kelly between your last date and this plea date. Is that correct?
so far as him decompensating or something like that, no.
And on the date of the plea, did you have any concerns about him taking the plea?
No.
Did he seem to understand the judge's colloquy?
Yes.
And did you have any issues with anything that was done that day?
No.
I want to talk to you a little bit about the self-defense. I'm going to show you states number 4, which would be your letter.
Before we get there, Ms. Ford, are you moving in states 1 and states 3?
Yes, and they are all part of the record as well.
Any objection? All right, we'll admit those respectively, states 1 and states 3.
So now we're on 6-4, and I believe this one's previously been entered.
Can you tell me what that is?
This is a letter dated March 18th of 2018 that I wrote to Mr. Kelly.
And why did you write that letter?
I guess to make sure there wouldn't be any misunderstanding about what was going on in his case. That reminded him of what he was charged with, what the maximum penalty was, that he had the right to take his case to trial, and told him what would happen during the trial briefly.
Is this a common letter you send to clients that may be anticipating trial?
Yes.
As a defense attorney, have you ever had to argue self-defense?
Have I argued self-defense? Yes.
And I think you previously said you didn't think the self-defense in this case was strong.
I did not think it was strong.
And is that due to the amount of stab wounds?
That's part of it.
And the defendant's statement that he killed the man inside with a knife who took his money?
That, when it was contradicted by the man who ran the place saying he didn't have any money.
And then his ability to present the self-defense claim, that also came into your legal strategy that it might not be the best strategy?
His difficulty testifying and convincing a jury he was acting in self-defense. Yes, that was part of it too.
I want to talk a little bit about the defense of insanity. Are you familiar with that defense?
Yes,
Have you ever filed a motion to have someone evaluated to determine if they were insane at the time of the offense?
yes.
What considerations would you make to determine whether or not you needed to look into that?
I can give you an example.
Okay.
I handled one case here in Washington County when we were in the old courthouse. This courthouse wasn't even built yet. And it was Judge Cole that was the judge in the case. And I had a client that was driving down I-10 and ran a state trooper off the road, and they put out spike strips and stopped him. And once they got him stopped, he got out of his truck and proceeded to run naked down the side of I-10 until they could catch him. And I thought that was really unusual.
So would you look at the facts of the case to determine if the behavior was out of the ordinary?
Yes, I mean, those facts are what I'm bringing up.
Have you ever had a client deemed insane at the time of offense?
I don't remember one.
In your experience, is that a rarity?
Yes,
Are there some things that might hinder an evaluator from finding that the defendant was sane at the time of the offense?
the thing that comes to mind might be drug use.
Drug use? What about their statements if they sounded coherent?
I'm sorry?
If the defendant gave coherent statements, would that hinder a look of
Yes,
insanity?
yes, I think I understand your question now.
I'm talking it backwards. So, but specifically, you talked about drug use. Would drug use impact whether or not someone would be deemed insane at the time of the offense?
The drug use just seems to cloud it up. I mean, that's what Dr. Schuler put her in her report, where she couldn't determine what was going on with him mentally because whether it was the drugs or whether it was mental illness or what it was.
In your estimation, would it have made sense to have Dr. Schuler reevaluate him for insanity at the time of the offense based upon that report that says that she didn't think she would be able to do that?
And I wouldn't have him reevaluated. That would be a reason.
I want to go back to the letter that you have, and that is, I think.
Hang on, Ms. Ford. It looks like the
Uh-oh.
prison is trying to reach out. I think you're muted, ma'am. We can't hear you.
Can you hear me now, sir?
Yes, ma'am.
Yes, hi. My name's Robin Williams. I am his classification officer. And as you know, we're an hour ahead of you. So it's 4 o'clock our time. So we're fixing to have shift change and he needs to return to his housing unit.
How much time can you give me, or is this the time where he needs to move?
This is the time that he does need to move. I apologize for that, but again, the hour difference facilitated this.
All right, so you're telling me that despite the fact that he is a critical part of this court hearing, that we can't proceed because he needs to go back to his cell?
Yes, sir. And our admin shift would be leaving at 5 o'clock. Like myself, I work 8 to 5. So, and I know with the time change and everything, but I just was wanting to let you know, sir.
Well, hold on for just a second. Let me make sure the attorneys, how much time they're going to need, because we're going to have to do this again, and we appreciate your cooperation. Ms. Ford, how much longer on
Could we
your
get
question?
5 more minutes? Could he set for 5?
Yeah,
Yes,
can you give
ma'am.
us 5 and I'll keep track
Yes.
for you?
I'll be
Thank you,
very
ma'am.
quick.
Yes, we can, 5 more minutes, we can do that.
Thank you.
Thank you.
All right, quickly, I want to look at that letter that you sent to Mr. Kelly. Do you routinely advise defendants of the maximum they can get?
Yes,
And why do you do that?
Why do I do that?
Mm-hmm.
So they can understand what their situation is. You don't need to be under any false impressions about this case. The most you can get would be life in prison.
Do you ever try to predict the results of a trial or what the judge would do?
No,
Did you ever tell Mr. Kelly that he would definitely get life if he was found guilty?
I've never told any client what they would definitely get. I may have suggested to him that there's probably a good chance that you could get life in prison if you go to trial and lose, but I didn't say it's guaranteed. That's going to be the result.
Nothing further.
You got 4 minutes, Mr. Quintana. Otherwise, we'll have to bring him back.
What ideas did this letter give, the report of Dr. Schuler give you as far as handling the rest of his case?
What ideas did it give me at the time? That he was going to be competent enough to proceed, marginally competent in some areas, but competent in all aspects. I went and discussed it with him. He told me what he wanted to do in the case at the end of our last conversation was to accept the 40 years. And I'm sure I talked to him in the courtroom before he came in to accept the plea, and I think he was okay with it then.
But you did tell him that you expected him to get more if he goes to trial. Is that correct?
I think that's a fair statement.
Okay. Now, this was a motion to determine competency proceed for trial. And this was done was requested in January and done in February. And his plea was in March, right?
Yes.
So at the time you received the report, you understood that we're talking more of a plea than a trial, right?
At the time I got the report?
Yes.
Well, it would be up to him, but yes.
Okay. Did it concern you? Did you have any concerns whatsoever about his ability to enter a plea based on his mental issues and his inability to communicate with you?
Whether he was able to enter a plea, I was not that concerned about that. I assume he's on some sort of medication that probably maybe have stabilized him from the time that the incident happened at the group home. He seemed lucid when he was in the courtroom. He seemed to understand what he was going on. Now, you asked me another question.
Okay, but the fact that he felt overly medicated didn't bother you at all in February, is that right?
It didn't mean that much to me.
I'm gonna go ahead and stop us.
Okay.
Now, if we need Mr. Griffith to come back, we'll certainly do that. And be mindful, I don't want to reopen the door on cross, but if so, we'll give the state a chance as well. So, Mr. Griffith, our apologies. Apparently, we have run out of time for the day.
I understand.
Thank you, Mr. Kelly. We will reset and conclude this hearing at a later time. Thank you, sir. We will stand adjourned at this time.
I'll be talking to you, Chris.